ametoa taarifa kwa maafisa wa usalama ambayo kwa sasa ndio andaye nasoma kama ushahidi wa hao ambao walishuhudia kisa hicho. Hebu kwa sasa tupate taarifa hiyo moja kwa moja kutoka mahakamani.
And the prosecution submits therefore that it has met the threshold of reliance upon circumstantial evidence to found a conviction against the accused person. The prosecution calls the defenses by the accused persons as stories that have been made up and incredible. The prosecution has discounted in their submissions the denial by the accused person that he was found in possession of a laptop with incriminating information, and said that PW44 gave evidence of the recovery of the laptop with incriminating material, and saw the evidence. So they were able to prove the ingredients of the offense under Section 9A of the Prevention of Terrorism Act. The prosecution submits with respect to the second accused person that according to evidence produced in court from the call data record, he spoke the most number of times with the third attacker, Ahmed Hassan Abukar. And we'll be looking at the number of times that that communication was done. That was not denied. They also argue that he also spoke to the first attacker, Abdinur, and the second attacker, Duhulo, on 18th of September, just a few days prior to the attack, and we shall also be looking at that. They therefore connect him to the attackers through the phone calls that were made. So the prosecution discounts the defense taken by the second accused person that this was because he used to share his mobile handset with his said brother Abukar. And what is material according to them is the line that was used in the communication and not the handset. Mr. Mbugu, I'm ready for the first, second, and third accused persons, and Mr. Chacha Mwita for the fourth accused persons filed submissions, both for no case to answer, and also at the close of the case for the defense. With respect to count number 1, Commission of a Terrorist Act, both learned counsel submit that none of the evidence of the prosecution witnesses places any of the accused persons directly or indirectly at the scene of the attack at Westgate shopping mall. With Mr. Mredi, learned counsel submitting that according to PW44 Sergeant Paul Maingi, the mobile phone data analyst, and PW45 ASP Charles Ogeto, the lead investigating officer, there were 4 attackers involved, and all of them perished in the attack. On the charge, on the second count of conspiracy to commit a terrorist act, learned counsel submit that that is Mr. Mugam Reidi, that the charge is incurably defective for failing to indicate the genus of the conspiracy that was charged as placed under Section 23 of Porter, that is Prevention of Terrorism Act. But I wish to respectfully disagree with Learned Counsel that submission that this section creates distinct offences. To me, the various subsections are explanatory of what constitutes and conspires to commit a terrorist act rather than creating distinct forms of conspiracy. I will therefore find the case cited by Learned Counsel Mr. Mbugwa of Kipkurui, Arab Sigilai and another versus Republic is not applicable in the present circumstances. Learned counsels have further submitted that the ingredients of the charge of the offense of conspiracy have not been proved against the accused persons, and he cited the following authorities. He set out 3 cases: Christopher Fula Makoha versus Republic, Republic versus Wycliffe Mwilu Mutinda, and Libazi versus South Africa. That is a South African decision. Setting out the ingredients of the offense as exposed in the above decisions, Learned Counsel submits that none of the prosecuting witnesses laid evidence to show that there was any agreement, consent, intention, meeting, or planning of the conspiracy between the first, second, and third accused persons among themselves or with the other indicated in the charge sheet as not before court. And Learned Counsel Mr. Chacha says that indeed there was no indication of any meeting or planning between the fourth accused person and the other 3 accused persons. And Learned Counsel further submits that there was no evidence laid to establish where the alleged conspiracy was hatched. Excuse me. Now, Learned Counsel submit that the prosecution's hold on the telephone communications between the alleged attackers and the accused persons does not prove anything. They submit that there is no evidence of communication between the alleged attackers and any of the accused persons during the surveillance or during the attack. Learned Counsel submit that there is no evidence of communication between the first, second, and third accused persons and any of the alleged attackers or his co-accused in this case. So Learned Counsel submit that in any case the communication link is weak and incapable of proving the charges. They cite the case of David Wahoma Njohi versus Republic on circumstantial evidence. So Learned Counsel submit that the circumstances of this case do not meet the threshold and unstated in the said decisions. With respect to the second accused person, Mr. Mbugua Mreithi submits that ASP Charles Ogeto gave evidence that one of the alleged attackers was a brother or a stepbrother to the second accused person, and this is a coexisting circumstance that will weaken the circumstantial evidence of telephone conversations between him and the attackers, as this will point to family conversations. With respect to the third accused person, the investigating officer in his case said that he was an employer of one Harid Abdulkadir Mohammed, who is alleged to have been linked to the purchase of the subject motor vehicle that was used in the attack, and therefore the communication between them would be innocent employer-employee relationship. Both learned counsels submit that there was no evidence laid to prove that the first, second, and fourth accused persons knowingly gave any support to the persons who are named in the charge sheet as the attackers. Mr. Mbugua Mreithi further submits that there is no evidence that links any of his clients, that is the first, the third accused persons, with the motor vehicle KS 575X, which was at the center of the attack. He says the said motor vehicle was not made available to court as an exhibit, and this, according to learned counsel, was suppression of evidence by the prosecution and should be construed adversely against the prosecution. However, in my analysis of the evidence, although the physical vehicle was not made available to court, photographs of the vehicle taken at the scene were produced in court and identified by witnesses who saw it at the scene. Although PW1 did not identify it properly, he all the same said he saw a vehicle from which the terrorists emerged. PW14 was able to identify that vehicle, and therefore the fact that the vehicle was indeed there and was used by the attackers cannot be disputed. There is also evidence from police witnesses whom I have outlined indicating what role they played, who responded to the incident, and also those who conducted investigations, who have given evidence that the vehicle remained at the scene and several exhibits were recovered from it. Therefore, the submission that there was suppression of evidence by failure to produce the motor vehicle is rejected. Learned counsel for the fourth accused person, Mr. Chacha Mwita, submits that none of the witnesses who attended the scene was able to link the fourth accused persons directly to the attack. In other words, learned counsel submit that there is no eyewitness who saw the fourth accused person at the scene of crime. Now, the other evidence adduced in support of the charges, that is the purchase of the vehicle allegedly used by the attackers, the purchase of the insurance for the said vehicle, and the exhibits recovered at the scene did not in any way link the accused person, the fourth accused person, to the incident, submits Mr. Chacha. Learned counsel, Mr. Chacha further submits that the officers who arrested the fourth accused person and allegedly recovered the phone from him were not called as witnesses, and this creates a gap in the prosecution's case as to how the fourth accused person is connected to the offences through his mobile phone. Learned counsel invites the court to consider the case of Cosmas Mate Kinyanzi versus Republic, where the court held that it is tried law that when the prosecution failed to call a material witness, they do so at their own risk. Now, the arrest of the fourth accused person and the recovery of the phone from him was not disputed by the fourth accused person. He also conceded that he was in communication with Abdinur. There is also evidence that line number 0725692951, which was registered to the fourth accused person, at one time was shared. He shared the phone with the said Abdinur, who was using mobile phone line number 0726658736. Learned counsel submits that the fourth accused person could have been a victim of his identification being used to register the line that he was allegedly using on the handsets. However, translate that. However, this contention is discounted by the fourth accused person's own evidence, where he says that he knew Abdinur and he was in communication with him. So the case of Abdul Muhammad Abdul Rahman versus Republic from Garissa, which was cited by learned counsel, Mr. Chacha, to buttress his argument, is thus distinguishable from this case. Now, counts 2, 3, and 7 are counts 2 is on conspiracy to commit a terrorist act. Counts 2, 3, 7 are conspiracy to commit a terrorist act and giving support to a terrorist group, respectively. Learned counsel submitted that there was neither direct nor circumstantial evidence against the accused persons, the only evidence being the telephone records that showed that there was communication between their line, and therefore the prosecution was inviting the court to speculate on what the communication was about. That the first accused person gave evidence that the communication was about business. And the explanation from the second accused persons was that one of the alleged attackers, Ahmed Hassan Abukar, was his brother. Now, they submitted that telephone lines communication do not incriminate any of the any of the accused persons. And they cite two cases for Faisal Mohid Ali and Abu Drogo Mahid, where the trial judge rejected the evidence of telephone conversations as evidence of a conspiracy to commit a terrorism act. Learned counsels further submit that giving support to a terrorist group must constitute giving tangible, material, financial, and logistical assistance, which the accused persons have not been shown to have done. On counts 5 and 6 against the first accused person, he stated that he was not found with any laptop. And learned counsel submit that whether or not he was found with it remained with PW31. Because there was nothing in the laptop to show that it belonged to the first accused person. He says that the videos that were on the laptop were played on YouTube and they were not saved on the laptop. And they say that YouTube is a public video viewing site. So, learned counsel submit that circumstantial evidence, however strong, cannot be a basis for conviction. And the report by PW44, who did the analysis of the communication, did not meet the threshold of determining a case purely on circumstantial evidence. Learned counsels refer to the case of John Muredi Nyaga versus Republic, where it was held that fantasies, theories, and reasoning cannot be a basis for a conviction. And according to learned counsel, this applied to the prosecution submissions, which were colorful and beautiful, but they could not be a basis for a conviction. Therefore, the prosecution had failed to discharge their responsibility of proving beyond reasonable doubt the role played by the accused persons in the Westgate attack, and so they submitted learned counsels that the accused person should be acquitted under Section 215 of the CPC. I have considered the evidence tendered by the prosecution in support of the charges, the defenses by the accused persons, and the submissions by learned counsels for the prosecution and the defense. I have also considered and analyzed part of the evidence in the summary of the evidence by the witnesses, as well as when considering the submissions by learned counsels. The issue for determination is whether the prosecution has proved its case against the accused, each of the accused persons on their respective charges. Beyond a reasonable doubt. So I'll take the counts now shortly, whether there is proof or not. Now, I've considered whether or not the charges in counts 2, 3, 4, 7, 9, and 12 were defective as considered as submitted by learned counsel Mr. Mbugua Mureithi. I have considered each of those counts, and I will skip that kindly. But the finding, I have considered the count of conspiracy, the submissions, the issues that were raised there, the citations, that is the authorities that were cited. I've considered counts 3, 7, and 12 giving support to a terrorist group. And in my final analysis of that on the issue of whether or not the counts as submitted by Mr. Mbugua Mureithi were faulty or defective to a point where the accused persons would not face a fair trial. So I have found, after analyzing each of those, I have found in some that on the submissions that some of the charges were defective. I wish to refer to the case of Abdrazak Mukhtar Edo versus Republic 2019, which was decided by G.W. Ngenye Macharia judge, where it observed, the learned judge observed in considering the issue of a defective charge. The learned judge said that in the instant case, let me just cite this, I'll explain what I mean. In the instant case, the charge sheet cited the offense and laid down the particulars of each offense in an ambiguous manner. The particulars clearly disclosed the offenses the appellant faced that he clearly was able to plead to and aptly defend himself. All the offenses are related to terrorist activities which are outlawed by dint of the Prevention of Terrorism Act, number 30 of 2012. In view of the holding by Ngugi J in the foregoing case, it cannot be gainsaid that the instant charge sheet is proper and drafted in accordance with the law. It suffices to state that not all information or fact of the case can be squeezed into the particulars of the charge. What is paramount is that the particulars disclose all the essential elements necessary for the proof of the offense. You translate the following. That decision, which also dealt with the charges under the Prevention of Terrorism Act, like in the present case, addresses all the issues raised by learned counsels as I have done above, and that some of the charges are defective, and I find that there is no defect in any of the charges herein cited, such as would lead the accused persons, would mislead the accused persons and cause them to fail to understand the cases that were facing them. The second issue for my consideration.
Mtazamaji, huyo hapo ni hakimu mkuu Francis Andai pale mahakamani Milimani, ambapo anatoa hukumu kuhusu washukiwa watatu wa shambulizi la jumla la Westgate mnamo tarehe 21 mwezi Septemba mwaka 2013, ambapo basi kwa sasa nazidi kusoma hukumu hiyo ambayo ni ndefu tu, kwani